Welcome to the Texas Appellate Law Podcast, the show that takes you inside the Texas and federal appellate systems. Through conversations with judges, court staff, top trial and appellate lawyers, academics, and innovators, we provide practical insights to help you become a more effective advocate. Whether you're handling appeals or preparing for trial, you'll discover strategies to sharpen your arguments, innovate your practice, and stay ahead of the latest developments. And now, here are your hosts, Todd Smith and Jody Sanders. Produced and powered by LawPods.
You're listening to the Texas Appellate Law Podcast. I'm Todd Smith.
And I'm Jody Sanders.
Our guests today are from Counsel Press. They are Vincent Wiscovitch and Janet Bennett. Welcome to the show.
Thank you.
Thank you, guys.
The first thing I need to do is just acknowledge that Counsel Press does have a relationship with the Texas Appellate Law Podcast. It is a new sponsor of our show. This is not going to be an infomercial, however. We're going to talk about some very practical things that I didn't know when I first got to know Counsel Press. And so, but just in the interest of full disclosure, let's get that out there. And now that that has been said, we're going to talk in detail about what Counsel Press does and how the services that it offers to, especially new services here in Texas, to not only appellate lawyers, but also, as I've come to learn, expanding into working with trial lawyers too. So with that, let me just ask each one of you to just introduce yourselves and give a quick synopsis of how you got to where you are in your career.
Okay. Thank you again, Todd and Jody. I don't know how often you have full-bred New Yorkers in your podcast, but I thank you for inviting me down to speak. I am a native New Yorker. I went to school at St. John's University School of Law, graduated there in 94 and practiced law probably for, I would say, good 10 years as a litigation attorney. I was an associate in a big law firm, Richmond-based, but New York office, where we handled a lot of complex litigation, some trademark, antitrust. We were working with Big Tobacco at the time in the 90s, so we were handling a lot of their class action cases. So I got a feel for what heavy litigation was all about. From there, I went to a law firm much smaller in size out in the suburbs and found that I was given a lot more responsibility to actually be a litigator, handling my own cases. When I walked in, they kind of pushed a cart to me and said, "Here you go. These are all yours now." So that was a big change from being locked in libraries and discovery rooms with thousands and thousands of boxes of documents, not just pages, to now really being a lawyer. And from there, I went to a small boutique shop in Manhattan, and it was geared towards intellectual property, trademark, and copyright infringement enforcement and litigation. So I had some great clients, world-known clients like Nike and Adidas and Tommy Hilfiger. So those were great experiences to work with high-caliber, per-echelon businesses. And then I got burned out. Quite frankly, being a litigator took its toll on me. I was fighting every day of my life, fighting with adversaries, fighting with judges, fighting with my own clients to have them get me documents or take the reasonable approach to something that's asked of them. So I did a complete 180 and went back to my roots in business. I had attended New York University undergrad and had a business degree in marketing. So I started a marketing consulting firm. From there, I had many clients and really got along well with one of them, a home remodeling firm that wanted to bring me on board full time instead of freelancing and working with various different companies. So they made me a chief marketing officer, worked with them for probably about 5 or 6 years until the market crashed and nobody wanted to remodel their home anymore. And so I guess it was 15 years ago, so 2010, saw an ad for Counsel Press where they were looking for attorneys to work for them in a non-traditional legal role. I said, that sounds interesting. Went in and interviewed, and as they say, the rest is history. I've been there 15 years now.
Wow. Okay. What about you, Janet?
Well, I guess I started my career in a non-traditional legal role. I graduated from Texas Tech Law School quite a while ago and joined Thomson Reuters, which at the time was West Publishing, but I joined them right out of law school and worked with Westlaw for a long time. I worked with in-house counsel. I worked with law schools, working with law review students and professors and first years, but worked with a lot with in-house counsel. I stayed with Thomson Reuters for over 25 years and worked in some other capacities with legal technology tools, competitive intelligence, always, though, with tools that were really about analytics and helping trial and appellate lawyers and litigators, some that were around business development, but they really kind of focused on the litigation side of things. So I've always been in that area and left Thomson Reuters when they had a big reorg and went to work with an expert witness company for a while and then landed here at Counsel Press back in September. So I've been in legal my whole life, just in other capacities. And so I was brought in to help us expand in Texas. Counsel Press has handled cases in Texas for a long time. We work in all 50 states and across all the federal courts, but we hadn't really had a presence here. So I was brought in to help with Texas.
Well, let's talk about what Counsel Press is exactly, because I knew of it before we ever met, Janet, and I mostly had seen it like advertised as, lack of a better term, a printing facilitator for U.S. Supreme Court briefs. And so that's the way I've always thought of it. Now, of course, my limited U.S. Supreme Court experience doesn't guide me very much on this, but y'all do that kind of work still. But as I understand it, that's actually a pretty small part of what you're doing these days. Why don't we talk a little bit about sort of what the company's focus is currently and just the services generally that you offer to lawyers in whatever setting, small firm, larger firm, et cetera.
It's interesting, Todd, that you said that you knew of us as Supreme Court printers, because that is a small portion of what we do, not because of the court. The court's the most important court in the country, but because there's so few cases that get filed there every year as compared to around the rest of the country. So it's true what you said, that we are known as printers. That's what the marketplace knows us as, but we are a lot more than that. And we like to refer to ourselves as appellate support providers, because anybody can be a printer as far as I'm concerned. You could go to Staples and get a brief printed or other documents printed up. You could go to Kinko's if they're still in business. You don't need a support company to do that. And the reason we try to position ourselves or educate clients on us being appellate support providers is because there's a need throughout the entire process for having your hand held, for lack of a better phrase, to guide you through the myriad of rules and regulations, both statutory and clerk made. Because you guys have been litigating enough, you know that you have to be friends with the clerks because they're the ones who will accept or deny your filing. And sometimes they're the ones who make the rules. And it's their baseball, their bat, their ballpark. You have to abide by it. Otherwise, you're not getting through. And that's where we come in as a support provider, because we know those rules. We know the statutes. Those are pretty easy, and any attorney can frankly look them up. But we have the relationships with the clerk's offices in all these different states and every federal court so that we can get those papers approved. We know when we're looking at something, well, this isn't going to fly. For example, in one of our New York courts, the clerks have decided that they do not want any emphasis added within the brief. So you cannot use any underlining, you can't use bolding, can't use all caps or anything like that. And when we tell clients you have to edit the brief, they say, well, where is that? I don't see that written anywhere. You're right, it's not. But when we file it for you and the clerk is looking at it, if they're doing their job, they're going to reject it. They'll give you the opportunity to correct, but then we're going to have to edit it anyway. And you're going to have to refile. You're going to pay our fee again for taking care of all of this for you. And then you have to explain to your client why you had to do it twice. So being an appellate support provider is where we like to be known as, what we'd like to be known as. And that, like Janet said earlier, is all across the country. We file in every single state. I looked it up, and as recently as last year, we filed in Alaska and had a filing in Hawaii. So, our range is far.
That is quite a big range of knowledge and responsibility to take on, to be able to file in essentially every state, the state court and federal court. It would seem like federal courts would be, that's pretty uniform. They're all operating under one big set of rules. And then, of course, you've got local rules and so forth. And then there's the local rules, which we like to joke about here locally in Texas. But I'm just trying to imagine taking on that breadth of responsibility, just in terms of geographically and different rules. Do you have some proprietary technology or something that helps you stay on top of this stuff? And how do you do that?
Hard work. I wish it was some kind of software technology. It's keeping in touch with the rules as they change. And what's great about Counsel Press, it's not just that we file in all of those locations, it's that we have experts in all of those locations. Janet is now our expert in Texas. So if I have a question from one of my clients in New York, one of two things is going to happen. Either I'll make an introduction to Janet so that she can handle the case for the client, or if it's a quick question where they need to know an answer, rather than me digging in and trying to find where a rule may be, I'll send Janet an email or give her a call, and likely she'll have a response from me in less than 2 minutes. And then I can share that with the client. And I just saved the client, I don't know how many hours of doing the research to find that answer themselves. This is true in all of the jurisdictions where we have our primary businesses: California, Chicago, down south in Florida, Massachusetts. We cover everything, but we have experts in a lot of different sections.
So there's some geographical diversity in terms of where you have offices or production centers. And I guess from there, maybe you were trying to cover sort of the Southwest, if you had a location in, say, California. Is that how it worked generally? But of course, the world is so small today with the way that we communicate that that's probably not even necessary anymore, it doesn't seem like.
Yeah, physical presence in a specific geographical area is definitely not required anymore. And during the pandemic, we, like many businesses, went to a work from home environment. Some offices wound up getting closed if they weren't needed for production. Our New York City production facility is a sight to behold. I don't know the square footage offhand, but it's probably printing area is probably the size of half a football field. So it's pretty impressive when clients come to visit and see how many machines we have going and the staff that's involved there. And sometimes that staff is working on weekends and overnight just to get clients' documents prepared and prepped for printing and out the door. But you're right that, even though we're a national company, we are definitely geographically centered in certain areas where we identified more need at various different times during our evolution. And Janet mentioned earlier that we hadn't been physically present in Texas, although we were doing work in Texas. And that's why the expansion took place last year, and Janet's now running a show.
What's the breakdown in jurisdictions between ones that just only e-file and ones that paper file? Are there still quite a few that do paper only?
No, not paper only. I don't think anyone does paper only. There are many jurisdictions that still do paper as well as electronic. And there are a handful of jurisdictions, it's a relatively small amount, that only do electronic.
Well, I'm grateful for that. You may not know this, Vince, but Janet certainly does. I mean, Texas was one of the leaders in getting electronic filing statewide across the finish line, or getting it started. And that was because our Supreme Court saw the future and said, this is the wave that's coming and we might as well get on board with it, and made it mandatory. So we're so used to electronic filing here and thankfully not having to follow up with paper copies in state courts anymore. I haven't held a physical brief in my hand and I couldn't tell you how long. one that was actually printed on like a blue or red cover. That's a sign of days gone by, I guess. So it sounds like you work with a variety of law firms. I mean, everything from a solo to a large firm. It's just a matter of those folks being aware of what it is that you all do, the full range of services that you provide, and how you can help.
Yes, that's true. We have most of the AmLaw 100 law firms working with us, if not all. They probably have all worked with us at one point or another, but I would say most are still regular clients. And we work all the way down to solo practitioners who may just be starting out or have been litigating for decades and just don't do appeals very often, especially, and want that guidance. Because there's so much involved and it's such a nuanced field, as you know, if you're doing an appeal once a year or once every few years, you have to start from scratch almost every time. So to get a partner involved with you that can tell you what you have to do, give you checklists, make sure you're on time, your deadlines are being managed, make sure that while you're drafting your document, it's already being done in the proper style and font and spacing, margins, everything like that. So that you don't have to stress at the end when you're ready to click send to us or to the court that you may not have a properly or compliant document.
Well, that's every lawyer's fear, is hitting send on an e-filing and have the clerk reject it for various reasons, including, as you were suggesting, Vince, some that aren't actually in the rules. So I'm sure that brings great peace of mind to folks who don't file. I'm thinking, primarily about appeals, but folks who don't file appeals regularly, to be able to engage and have y'all kind of ride along as I like the way you phrased it, appellate support providers, because I can totally see, depending on the practice situation, how that would really add a lot of comfort and give a lot of comfort to lawyers who aren't as familiar. What about experienced appellate lawyers or law firms? I would imagine that you've got in addition to a lot of variety in terms of firm size you work with, it's probably the same for the practice areas that you're working in. Civil litigation generally, and the occasional appeal, versus a firm that actually, say, focuses or specializes in appeals and just leverages you all to add to their work capacity.
Yes, that's very well put, because we do work with both of those and everyone in between. When you're talking about the firm that does appeals on a regular basis, I have a client who probably does at least 2 per month on average. Some years it's even more. And those are the ones that he's appealing on. Then he's on the responding or the appellee side on probably 2 more per month at least. So he's good for about 50 appeals per year at least. And he knows all the rules. He schools us if we're trying to tell him something and says, "You think I don't know that? Of course I know that. I'm still going to do it anyway." And I said, "Well, I'm putting that disclaimer in the email anyway, John. I'm just using the general name John here, because if it gets bounced, you know what's going to happen." Yes. If it gets bounced, I'll deal with it. Some of them do. Some of them get turned back and he deals with it. But because he has been doing it for probably as long as I'm practicing, he has his way of doing things and getting it done. And you also have the large firms who have appellate sections and divisions. And you would think that, maybe they wanted to handle it all themselves. But that's usually not the case, because they working on their own a lot of times creates extra work that has to get written off that they can't bill their clients for. I don't know if many of them bill for researching what the rule is on how to prepare a brief in this particular jurisdiction, or whether putting together a record on appeal is something that they can bill an associate's time for at that level. Whereas when you bring on a support provider, our invoice typically just gets passed off to the client, so they don't have to worry about it. And then they can focus on what they need to focus on, which is the argument in the brief, the research, the writing, making sure that they have all the documents for the record that they preserved properly in the lower court. So those are the areas that we tell them that's where you should be focusing on. The other stuff, pass it off to us. Let us take care of it.
You mentioned building a record on appeal. Is that something that a lot of states require the actual attorneys to do, to put together your own record as opposed to the court doing it for you, the trial court or the court reporter?
Yes. Most courts require either an appendix or a record on appeal, which be the superset of documents, and then you derive the appendix from there. And it's usually the appellant's responsibility to prepare it. Sometimes it's a joint responsibility, especially if there are multiple appealing parties. And in some federal jurisdictions, it's required to be a joint appendix so that the parties are at the very least supposed to confer with each other to discuss and agree upon what documents are going into their appendix or record excerpts.
When the stakes are high and decisions must be made quickly, you need someone you can trust. Port Surety Bond Agency is the nation's leading surety agency, specializing in supersedeas bonds. CSBA can handle any size bond ranging from a small temporary injunction bond to a $1 billion appeal bond. If your client needs protection against judgment enforcement, contact CSBA today.
Well, I see just from looking at the list of services that you all offer, I mean, obviously, we've talked about brief preparation. I think that involves, as I understand it, basically, I give you my work product and say, here's a brief, get it ready to go. And it's literally Counsel Press handles everything else from that point forward, subject to review and approval. So that's pretty easy to understand. But the idea of getting help putting together the record to follow up on Jody's question, is a little foreign to us because we're used to working with the court staff directly on getting that done. And Janet, maybe this is a question for you. In Texas, is that something that you all are taking on to interface with the clerk's offices and court reporters?
Not so much interfacing with them because it's easy to request the record be sent. But where I'm running into this is in the Fifth Circuit, if it's a case with an agency where they only provide a list or an index of the record, and so then the attorney's having to gather that, and we're helping put that record together for the appeal. Or if an attorney's filing a petition for writ of mandamus, we've gotten involved in helping build those, which can become quite voluminous and a lot of work for the attorney and the paralegal. So we're not involved in that as much, but there are situations where we can come in and take away part of that burden and help the attorney organize it.
Yeah, I was thinking about Mandamus as you were about halfway through your comment, and you mentioned it specifically. So y'all would go then, we more or less would identify the documents that we wanted to include potentially in the Mandamus record. And Counsel Press would go out and get those documents and get them in the form that we would need them to be in to file them as a Mandamus record.
Usually the attorney's gathering those and then sending them to us.
Okay.
Then we'll put them together. We'll bookmark them. We'll do all the file.
Okay. You're compiling the documents.
Mm-hmm.
Okay. Makes sense.
Mm-hmm. Yeah. And also it's easy for an attorney sometimes to just mark up the docket. And if they don't have time to pull everything off of Pacer, they'll circle or highlight it, pass it off to us, send it to Janet. And we have folks, sitting back in the office that go on and pull all the documents, save them as proper PDF form, and take that step away from the client as well, which, it's one thing to sit there and circle what you want. It's another thing to actually go in and one by one download everything. So it's a time saver there.
Yeah, that is a very time intensive thing to do. And I find doing mandamuses pretty regularly, it's time intensive, but it's also extremely important, I think, sort of first step in the process. So having some help and some additional support on that, I think would be really beneficial. But I also see it in your service offerings, that you all do things that this is where we really get away from being a printing house, doing blue booking, shepherdizing, citation verification, sort of thing. Let's talk about that for a minute, because I recall from being a young lawyer in a very large firm, we had paralegal or two or designated as being the site checkers. And of course, on my own now as a solo, I don't have that luxury available to me anymore. But I guess maybe I do, because Counsel Press can offer that sort of thing, right?
That's right. And we take it even a step further, Todd. We have attorneys writing briefs for other attorneys, ghostwriting. So let's say you have 2 briefs due in the same month and you really want to focus on one more than the other. You can say, hey, I want Counsel Press to write this one for me. And of course, it's prepared and then sent to you a few days in advance for your review and comments and edits. So it's a legal research and writing group that we have. There are attorneys who do that aspect, do the writing, and then there are others who will sit and review your brief for you and criticize it and tell you, hey, this is where your argument is weak. This is where you can improve. This sounds great. Maybe you want to do a little different wording. And then we have the other types of services, as you mentioned, where maybe we'll just do the blue booking, make sure everything's in proper format, prepare your table of authorities for you, make sure the sites are what the court wants, because there are certain courts that don't just want blue book format. They want their own specific format. So it's our obligation to know what that is, make sure that your brief complies with it. And if you prepare it, fine, we'll review it for you, make sure that it is compliant. But if you want us to do it, we'll prepare it too and make sure that it's compliant.
So it sounds like in that situation, with having attorney support, just in terms of the economics of how that works. I mean, you were talking about basically passing off the final preparation cost of a brief and so forth to the client. I assume that's just passed along generally as you all are a vendor and it's just a hard cost that gets sent through. But lawyers, having lawyer help is a little different animal, I would think. And so I suppose that Counsel Press probably doesn't get into the details of how the lawyer client bills those services to the law firm client. What kind of conversations do you have with lawyers who are interested in using the attorney support services about how that process works in the payment arrangement?
The payment is always from the attorney. We are not allowed to accept payment from an underlying client when we're doing the brief writing, because then it crosses the line and it's as if we were representing them. But as I'm sure you're aware, there are many companies out there that just do brief writing. They'll do ghost writing for various different law firms or individual attorneys. So we make sure that the communication is with the attorney. We don't really get much involved in how they bill for our services to their underlying client. I would suspect that some of it's passed through, some of it is added on by them because they still do have to review our work. I would not recommend any attorney allowing me to write a brief and then just go file it with their name on it. It's that we're all 4 of us are attorneys here. That would be very, very risky behavior. So having the time to review it and then make your edits, etc., it then ultimately becomes your work product that was prepared originally by us. And in your situation, Todd, it's a perfect example where you don't have that other support. It's almost like having a 5th year, like a junior partner, the one who heads our legal research group, but at the price of a 5th year associate preparing a brief for you then to review and put your name on. And it's being prepared by someone who has written hundreds of briefs in her career. So it's like having an outsourced associate.
I don't know, Jody. I think we have to rethink this arrangement with Counsel Press because it sounds like they might put us out of business. No, in all seriousness, I'm just intrigued by the whole just range of things that y'all are able to do. And as someone, and this is true for, I think, everyone listening to this, but as someone who doesn't have enough hours in the day most days, I can really see the value in the right situation to certainly when it comes to finalizing a brief. I mean, we tend to be pretty wedded to our process of preparing briefs and pretty leery of signing our name to work product prepared by someone else. At least these days we should be. I'm just super interested in y'all having now entered the Texas market. I get the reason. I mean, we have 15 intermediate appellate courts in Texas now. Plus, we've got, a lot of cases going up to the 5th Circuit and other places and business courts. And this is a very active hotbed for litigation. So I assume that was one of the drivers for Counsel Press trying to plant its flag in Texas.
Yeah, I think you're absolutely right. In fact, I'm at a CLE program today, and we just had the 15th Court of Appeals come and talk about the cases coming through their court today, through court now and what they're experiencing. But, there's a lot of litigation in Texas, and I think Counsel Press just saw it as an opportunity to be able to grow our business here. We already did work here, but we didn't really market heavily in Texas, or I'm not sure they marketed much at all, except maybe around some Fifth Circuit. So we saw this as an opportunity to grow, especially with the business courts growing, because we have clients who have hired us repeatedly in Texas. So I figure there's probably others who could use us.
Well, that's a good launching point. If you've already got clients here, and I think I mentioned that how you and I met was at a CLE program where Counsel Press was a sponsor of the program. I'll mention that, and I'll go ahead and mention our other podcast sponsor, Court Surety Bond Agency, because y'all were two of the vendors that were at this relatively small CLE program. And if you hitch your wagon to CSBA, they're a good group to follow because they're very well established in the appellate world here in Texas. But I would have to think that your experience as a Texas lawyer and relationships that you made when you were with Thomson Reuters probably were a big factor in thinking that this could be a successful venture for Counsel Press.
I mean, I think so. I've been out of law school for quite a while and just always enjoy the litigation side of things and the legal research side of things. So it seemed like a good fit and a good opportunity for the company to grow and a need. So.
Sure. Well, and you're being a Texas lawyer, you're familiar with our eFiling system specifically, which has its quirks. It's not quite like Pacer, but I think generally it serves us well. Is there anything about eFile Texas that you think is unique, or in your experience with the Counsel Press so far, or the things that Counsel Press can help specifically Texas lawyers to get their filings accepted without getting bounced, as we all are loath to get that bounce notice?
Exactly. I haven't run into anything specific that I would say is that different about the eFile Texas. One thing that I think helps us is that we have a very large paralegal team. So we're able to have paralegals that are focused on particular states and circuits. And for instance, I have 2 or 3 paralegals that handle most of the Texas cases. So they're very used to the Texas system, and that seems to go off without a hitch. And same for the Fifth Circuit. They know what to look for. And when somebody does submit the brief or the record, they're very quick to identify, here's something that's missing so that it doesn't get kicked back. Not that it will never get kicked back. Sometimes we have a client who wants to do it their way, like Vince said, one of his. But the paralegal team that's doing this work does it so frequently that they really know what to look for. So the e-filing system itself has not been an issue. I will say one area that, and I've only been with Counsel Press since September, so I don't know all the ins and outs of every court, but the paralegal team's been really good at identifying those ins and outs. And part of what makes us special is trying to know what the nuances are of different courts. Like Vince was talking about the emphasis in briefs. Just as an example there, we had a client who wanted to file a sealed brief in the Court of Appeals in the 7th Court in Morello. And I called the court to ask how we should do that. They said to file it electronically, which the rule I was reading said do not file it electronically. So I asked them a couple of times about that. And they were adamant about, no, file your motion to seal and file it electronically and it will be okay. So I called them again before we did that, and it all worked out, but it really made me nervous. So
Oh, yeah. I can understand why.
I was checking that docket every day to make sure that it was not available to me. But then turned the page, and we had another one filing in the 5th Court of Appeals in Dallas. I called them and asked them, do you also want it filed electronically? And they were quick to say, no, we want it paper only. So, part of our job is to know what those nuances are, to call the courts when we don't know, and to make sure everything's done the way it needs to be, to keep our clients out of hot water and make sure it gets filed appropriately.
Going back to Mandamus a little bit, I had an issue recently. This is, Jody, we have the opportunity to ask the experts, right? I had an issue recently where I was mandamusing a trial judge, then mandamusing a court of appeals, which is lots of extra fun. So filing in the Supreme Court and figuring out, how can I serve this, being mandamus and being a complex commercial case, ginormous mandamus record in the petition on the Court of Appeals? And so I could have used you because I got conflicting reports from the clerk's office on how to do that. At least these days with trial judges, generally, they've got a staff attorney or a judicial assistant who has a published email, and you can actually, find a way to serve them electronically. If not, like in Travis County, they've got designated emails for the courts. So that's easy. But I found that the Court of Appeals in this particular case was not too excited about giving out an email address for service, which left me to, my alternatives were send a paper copy, which it was thousands of pages. The better, the I think funnier alternative, not funny, really, haha, just funny, was, e-file it in our court. So I'm going to plant that seed with you for further discussion, because if Counsel Press can figure out a way around that issue so that I can actually e-file and e-serve a Court of Appeals that I'm mandamusing, that would be worth a lot to me. Have you seen anything like that come up yet? I know you're still relatively new at the company.
I just helped someone file one in the Supreme Court of Texas, and we did not have a problem. We didn't have that kind of problem. I didn't have any problems, but I didn't run into that. Vince, have you run into anything like that type of situation?
No. There definitely are times when service is a little squirrely and you have to find out what this particular court wants in a mandamus situation. Sometimes it's clear from the rules, but yeah, that's our job. And sometimes it is making multiple phone calls, and sometimes it's multiple service. Your situation, Todd, we may have done both. We may have done the print, said, let's do it, and we'll do the e-file as well, just so you have the belt and suspenders, just to make sure.
But I guess one broader point in this conversation is y'all would be settling and sorting that out as support, and I wouldn't have to spend time on that.
Exactly. Time, energy, your mental bandwidth, any of that stuff.
Appeals can be complicated. With ever-changing rules and procedures, clients need a partner who understands the nuances of every court's demands. Counsel Press has been the trusted appellate services provider for top law firms since 1938. Their team manages everything from complex document preparation to e-filing, ensuring filings are compliant, accurate, and on time. Let Counsel Press simplify the appellate process. Trust their experts to handle every detail. Visit counselpress.com today.
What are some ways that Counsel Press kind of leverages technology? I know, Janet, you came from a legal tech background. What do y'all use, I guess, either internally or make available to your clients?
We are probably the most cutting edge technological company in this field, both on the proprietary side and how we work with other courts. We were doing a product called eBriefs long before it became popular and well known, where our team would take a brief that you prepared and then create links to either Lexis or Westlaw or the appendix or record, so that the reader of the electronic version would simply click on it and open it up in another window. Whatever you clicked on opened up in another window. It's fairly common now, but we were one of the first companies to ever do it. More and more courts are accepting e-briefs. More and more courts love it. I think it's a great product. I've read some of my clients' briefs, and I think it's great to be able to click on something and then have that source open up, whether it's a page from the record that you're referencing or a citation and a case, and it jump sites right to that particular page. So that's one area where we've been on the forefront.
And Vince, I'll kind of add in, I've been on a few of these programs where panels of judges are talking about what they prefer. And it's not a requirement in Texas to have those links, but almost all of them I've heard say it's not required, but we appreciate it. So anything that makes it easier for them, I think, makes it better for the appellate attorney.
Well, and the idea of me preparing that as opposed to outsourcing that, well, Jody, you're laughing at me, but I'd say the same for you.
No, I know. I'm laughing because I get it. I'm not disagreeing with you.
And the thing is, you're intelligent attorneys. You could do it. You'd muddle your way through it. But question this is, how much of that time are you going to bill your client for when it's like a quote unquote ministerial type of act that may have taken you 15, 20 hours to do on your brief after you just spent 70 writing it, are you going to be able to recoup that cost? If so, great, wonderful. Why hire anyone? But chances are you're not. So you're going to have to lose some, if not all of that time, which you could have been using something else.
You're right. A lot of us could figure out how to do that stuff, but I didn't spend 3 years in law school to that be one of my major marketing points. So no, I'm really grateful to hear about that, because I know that our courts, as Janet said, we do see comments that the courts really do appreciate the e-briefs, or we might call them, fully hyperlinked briefs or something equivalent to that. But I did also see that you all do something a little different, which is, are y'all hosting like a cloud workspace that allows records to be uploaded and all of that? Or tell me about that if I'm getting that right.
Yes, you are. It's a client portal, which is in our infrastructure, the proprietary technology, where our team has built a Dropbox type of interface, let's call it, with our clients so that they can give documents to us and we can give documents to them. It makes it very easy because whoever else is on the case will have access to it. So you don't have to email these large documents and files to multiple people and hope that they get through and don't get stuck in spam filters or crash somebody's email or just never get any kind of acknowledgement whether it was received or not. So it's great because let's say the two of you are working on a case together, can both be on that file. So you would only have access to those documents. It's not every other case that you're working on, Todd, that Jody may have access to, and vice versa, if you guys didn't want that. So it's whoever's on that file. Makes it good because if you have secretaries and paralegals from the law office who sometimes are the ones who are dropping off the documents, they have access too.
Is that something that I could share with my client?
You could if you want to. You may not want to because the invoices go up there too. So it depends upon the relationship you have with your client. But yes, by all means, all it takes is an email address, and then we send a password. It's all encrypted, so it's protected, multi-levels of protection on it. Everything gets backed up as well. I think we have 3 different backup locations now, so that if ever there is a power failure or some kind of problem, we do have our resources backed up as well.
I mean, I could actually see if we were using you all as, I keep using the word vendor, but yeah, it's so much more that you guys do.
How about partner?
Provide, service provider, support provider. I like that one a lot. But if you're going to pass along, let's say it's one of those arrangements where it's basically I'm doing the legal work and primary drafting, and I'm getting help with the mechanics of putting the brief together, site checking, eFiling, and that sort of thing. I wouldn't have a problem at all with the client having access to that and to the invoices directly in that portal. And in some ways, it would really kind of simplify things because, to focus the client's attention on, look, here is your appellate record, and here is your appellate brief, and here's the invoices for the support provider that we've used and retained to help us put together this fantastic looking work product. That's just, I don't know, that's something that I'm intrigued by. I also see, because I know you guys are offering more trial level stuff these days too. And I saw a reference to MDLs in connection with that database. And boy, I could sure see some value in running it in the MDL record and, keeping MDL files in that format so that it's accessible. Probably there might be a benefit, I would think, to having it accessible to not only one party, one side in the case, but also to the opposing side, kind of like some of the better known litigation file share sites that managing that just incredible volume of data easier and better for everyone.
Well, we actually purchased one of them at the end of last year. Case Anywhere.
Case Anywhere, okay.
One of the biggest players in that field is now under the Counsel Press umbrella. So we are able to offer those services to clients who are involved in multi-district litigation, antitrust lawsuits, product liability lawsuits, all these things where there are thousands of players, either on the plaintiff side or on the defense side. And everyone who has login access to it gets to see those documents. And what's great about it, it's a real-time platform. So if you post a message up there, everyone on that platform gets the message that was sent from documents. Totally secure. So all the documents that are being hosted are protected. And that was, Janet, if I remember correctly, at the end of last year, beginning of this year, was the merger acquisition.
Yeah, I think so.
So what are you all thinking in terms of the hottest topic in law these days, which is how to use AI or how not to use it?
Yeah.
We like to joke about.
Yeah. Yes. The how not to use it with letting AI prepare your brief for you or write your brief for you. I'm sure you guys have seen or heard of some reprimands, to use probably the least offensive word, that have come out of courts and judges. But the AI has its place. AI is not going away. We've been using AI for decades already. I shudder to think that it's going to create lazy lawyering, as I'd like to call it.
Well, at the CLA program that I was at this morning, that was a topic of discussion for about 10 minutes at the end of an ethics session. And it was all about, do we sanction lawyers? What do the rules say about this? How do we handle it? And I heard some comments from one attorney that said she keeps seeing these fake cases pop up in opposing counsel's brief and not sure how to handle it. So, and a judge was asking the question about how other judges handle that. So it's still a topic of discussion. But I'm with Vince. There are places for AI, ways to make it easier to use or easier to compare cases to. There are places for it. I mean, it has been out there for a long time, from Westlaw natural language years ago to the way things chat GPT today. So there are places. I think anybody just needs to be very careful and check your sites, read the cases. You can get some help, but it's not going to do it all for you. Responsible AI.
We certainly advocate that. I'm thinking more along the lines of, how do you think the Counsel Press might wrap AI into its service offerings going forward? Is that in part of the development plan?
I believe in part of record retrievals. I don't mean a record on appeal. I mean document retrieval. I think that's someplace where we can definitely utilize it, where we can get notices of appeal just as quickly as you filed it and categorize certain notices of appeal so we know what type of case it's coming from. And that could help us focus more internally as a team. Do we have, certain people who focus in certain areas of law? So I can see something like that happening.
Well, we're kind of reaching the end of our time here. And I guess we have a couple things one thing we usually do to wrap up, but there's one I want to kind of pitch to both of you to think about. I mean, if there's sort of one thing that a Texas lawyer could do tomorrow to make their next appeal smoother and easier to do, what would you say? What's your advice?
Well, my advice would be use Counsel Press.
Oh man, that was a softball.
Fair enough. Yeah, there you go.
Janet hit it out of the park.
Call Janet Bennett.
There you go. There you go.
In all honesty, though, I think it's just trying to be as aware as possible of the rules and the requirements and nuances. That really is where we come in. And if you're working with us to communicate be very clear about timelines. Just as an example, I had an attorney that called us on a Thursday or Friday, and asked if we could file an amicus brief that's being written by one of her professors the following Friday. So I'm like, no problem. And then I talked to them on Monday, and they want to file it that day. And it was one where the Supreme Court had asked them to file it. So you want to get, you want to keep the U.S. Supreme Court happy. Anyway, we got it done for them. But when I discovered that at about 2:00 in the afternoon, I wasn't sure if we could make it happen, but we did. And we got it done for them. So, and that is one thing, we can usually handle things when others can't. But I think the attorney knew the deadline. The professor had something else in mind. And so we got it done. I think just, being aware of the rules as much as possible. And if you don't know them, asking for help.
What is kind of your ideal turnaround time? I recognize if you have to get something done, you can get something done, but what do you kind of advise people that work with you on that?
That's a great question. So a lot of vendors or a lot of providers that do things like we do require you to have the brief to them the day before filing, at least. We ask that you have it to us by 9 a.m. the day of filing, especially if we're going to prepare your table of contents and index the citations. Sometimes we can make that happen at 10, but we can get things turned around as long as you have it to us that morning that it's due. If we're dealing with the record, which again, for Texas, that's not as frequent, but if we're dealing with the record, we really need to start on that about a week in advance because that can be more cumbersome and just take a lot more time to organize. And you might find that things are missing that you want to add, and that can take time. We have a pretty quick turnaround. We have a large team of paralegals, and they're organized in such a way that it's a pretty fast process.
I would assume that the e-brief preparation process would be longer.
We need that a couple of extra days ahead for that to happen. But, just because it's another step. And if we're ghostwriting a brief for you, we would probably want to do that a couple weeks out so that you have time to review it. But I don't know that a couple of weeks is always needed. We just have to make sure that we have somebody available that can write it for you, that they're not writing 5 other briefs that same week.
Well, and then our kind of final wrap up, and you've hit on some of these, we always like to ask our guests for a tip or a war story. And I imagine between the two of you, you've got quite a few of both. If anybody want to throw one out there to wrap us up.
I'll take off on what Janet said as a tip is to get assistance as soon as you can after filing your notice of appeal or when you know that you're going to be appealing. Because one of the most difficult discussions I ever have with my clients is when I have to tell them that they've missed their time or that the document that they gave me to appeal and prepare a record for is not an appealable document. That's a tough conversation because now they have to go and explain to their client that they may have missed a window, because that's one of the few things that not much forgiveness on. You miss a deadline for filing a notice of appeal, you're usually out. Perfecting the appeal, a lot of courts are a little bit more forgiving, but noticing it, putting everybody on notice that you're about to embark on an appeal, that's a tough one. So as soon as you know you're doing it, get some assistance if it's not something that you're handling on a regular basis.
Well, that's a great piece of advice and certainly appreciate that. Vince, nice to have you down virtually from New York. And Janet, thank you for being with us too. We're grateful for the time that you spent with us. And I've learned a lot about what you all are doing in terms of your business model these days, and look forward to following you as you continue to expand your services in Texas and elsewhere.
Yes, gentlemen, thank you very much. We really appreciate it.
Well, thank you for having us on today.
Thanks for listening to the Texas Appellate Law Podcast. If you enjoyed this episode, please share it with your colleagues and rate and review the show on your favorite podcast platform. To connect with us, suggest a topic, or inquire about being a guest, visit texapplawpod.com or find us on LinkedIn and X at TexAppLawPod. Produced and powered by LawPods. The views expressed by the participants on this podcast are their own and not those of their law firms, courts, or employers. Nothing you hear on this show establishes an attorney-client relationship or is legal advice.